Here at Scott Legal, we know the ins and outs of immigration. We are here to help you navigate the oftentimes complex road in achieving your immigration goals. We have new immigration videos every week. If you are new to the channel, please hit the subscribe button and bell. You can also sign up for one of our webinars, or get a free immigration guide, by clicking the link below. In this video we'll be looking at important issues related to applying for US citizenship, based on a green card obtained after marriage to a US citizen.
If I obtain my green card through marriage, can I still apply for citizenship within 3 years of obtaining my green card if I divorced my US citizen spouse?
Eligibility for United States citizens is based on a non-citizen possessing legal permanent resident status, also known as a green card, for a period of 5 years. If a green card was obtained through marriage to a US citizen spouse, the legal permanent resident spouse will be eligible to apply for citizenship 3 years after obtaining the green card. A person is ineligible for applying for citizenship as the spouse of a United States citizen if before or even after the filing of the application, the marriage ceases due to death, divorce, or if the citizen spouse has lost his US citizen status. The applicant's spouse must be and remain a US citizen from the time of filing of the application, until the time the applicant takes the oath of allegiance. If the US spouse loses citizenship status, or the marriage ceases during any time before taking the oath of allegiance, the applicant loses eligibility based on being a legal resident for 3 years. However, as previously mentioned, the applicant can still qualify for citizenship after being a legal permanent resident for 5 years.
Will my eligibility for US citizenship be affected if I received a conditional green card, due to my marriage existing for less than 2 years?
No. If the green card was granted with the marriage existing for less than 2 years, the non-citizen will be granted a 2-year conditional green card. This will require the non-citizen to process a renewal of his status through a process called removal of conditions. The good news is that this process will not bar the non-citizen from accruing the required 3 years for the green card, but may need to file both the removal of conditions application and later the naturalization application once the 3-year mark is reached.
What if we were married for more than 2 years before I obtained the green card?
This additional time in marriage will not help with your eligibility. Time in marriage before obtaining the green card is not considered, only the time in marriage after obtaining the green card up until the oath of allegiance. The law specifically requires being lawfully admitted for permanent residence within the United States for at least 3 years, and during the 3 years immediately preceding the date of filing his application has been living in marital union with the citizen spouse.
What if I was only separated from my spouse?
This depends. A marriage is considered to have ceased if the marital union ends due to the following. 1. Divorce or annulment. A judicial divorce or annulment breaks the marital relationship. As a result, the applicant is no longer the spouse of a US citizen if the marriage is terminated by a divorce or annulment, which will then result in the applicant not being eligible to naturalize as the spouse of a US citizen if the divorce or annulment occurs before or after the naturalization application is filed. 2. A legal separation. A legal separation is a formal process by which the rights of a married couple are altered by a judicial order but without eliminating the marital relationship. In most cases, after a legal separation, the applicant will no longer be actually residing with his or her US citizen spouse, and therefore will not be living in marital union with the US citizen spouse. Furthermore, if the applicant and the US citizen spouse continue to reside in the same household, the marital relationship has been altered to such an extent by the legal separation that they will not be considered to be living together in marital union. As a result, the non-citizen will be ineligible for naturalization in the event of a legal separation. 3. Informal separation, where the informal separation may suggest the possibility of a marital disunity. These cases are evaluated on a case-by-case basis to determine whether it is sufficient enough to signify the dissolution of the marriage. An officer evaluating the marriage will look at the length of separation, whether the non-citizen and his spouse continue to support each other and their children during the separation, whether the spouses intend to separate permanently, whether either spouse becomes involved in a relationship with another person during the separation. As a result, a brief and informal separation, where the couple is back together, will likely not lead to a finding of a disillusionment of marriage. Note that involuntary separation, such as a separation due to military service or an essential business or occupation's demand, even if prolonged, will not be considered to have ceased the marital union. Regardless of your marital situation, if you desire to become a US citizen after obtaining your green card, we are here to help guide you through the various eligibility requirements for citizenship. To learn more, take a look at our resources in the description box below. You can also sign up for a free visa guide any of our upcoming webinars, and Facebook groups. You can also schedule a consultation for a date and time that is best for you. We are here to help. You can contact us by calling 212-223-2964 or by sending us an email. We look forward to hearing from you.